Sorry.
Oh, that's right.
Is he on the golf course?
Andrew's got
He's ill.
bronchitis.
Oh. I hadn't heard that.
Okay, good afternoon, late afternoon. I'd like to call the Shenandoah County School Board work session for February 23rd, 2023 to order. Do I hear a motion from my colleagues to approve the agenda as presented?
I move to approve the agenda as presented.
Thank you, Mr. Gutschall. Do I hear a second?
Second.
Second by Mr. Barlow. Discussion? All those in favor say aye.
Aye.
All those opposed? The motion carried 5-0. Our good colleague, Mr. Keller, is ill. Special education presentation, Ms. Shepherd.
Yes, thank you. So at the February 9th school board meeting, Jennifer Stratton presented information on the December 1 child count. And tonight's presentation, or this evening's presentation, is a follow-up on that presentation with our responsibilities for students with disabilities. So I'm going to introduce Mr. Brad King, who is an attorney for Sands Anderson, and he is going to share some information with us.
Well, good evening, Chairman, members of the board, Madam Superintendent, and the folks in the room. I think it would be fair to say that the IDEA and responsibilities to school divisions may be the most widespread and deepest sort of obligations that school divisions have. At least it's among them. And yet it doesn't always garner the kind of attention that I'm glad the superintendent and the board decided was important for you all to hear about tonight. Just by way of example, our firm has 10 full-time school board lawyers. And I would represent, I think fairly to you, that 5.5 to 6 do nothing but special ed law full-time. The rest of us do a lot of other things as well, but even the remaining 4 of us do special ed law also. But it is a mandate that comes from federal funding, and if you accept the federal money, then you are obligated to do the things that we're going to talk about this evening. I would also tell you that there are conferences that go on for parents, for educators, for school board members, and otherwise, lawyers. They go on multiple days, and each of the topics that I'm going to spend 38 seconds on this evening often are the objects or subjects of hours-long breakout sessions just to discuss these issues. Hopefully in a few minutes you'll see why that's so. I certainly invite any questions as we go. This is a cloud level conversation because of what I just told you. I could easily do, for instance, my friend here just advised he's going to give you some updates on some discipline matters. I could spend 4 hours talking to you just about the requirements of disciplining students with special needs. But we're going to cover some of that near the tail end of this. So please jump in if you can. And again, if staff wants to comment on how you're handling those things so the board members are familiar with what's actually happening here in Shenandoah, then please do. Okay? All right, so right out of the gate, I think this is fun. Get used to the acronyms. And if we had a bouncing ball, I'm the son of music teachers, so maybe we'd have a bouncing ball from the old days. Right? Get used to the acronyms. Under the IDEA, an LEA must evaluate potentially eligible students for SLD, ED, HI, SLI, OHI, and other identified disabilities. The LEA must provide FAPE to all eligible students pursuant to properly crafted IEPs. Parents who disagree with what is offered may complain to the USDOE, OCR, VDOE, or initiate a DP hearing. They may also request, in some circumstances, an IEE. The LEA must conduct an FBA and develop a BIP for students who demonstrate behavioral issues, and an MDR must be conducted if a recommendation is made to impose discipline that constitutes a change in placement. The LEA must provide PWN before proposing or refusing certain actions, such as updating a student's IEP. There is my presentation. Does anyone have any questions? Right, you get the notion. There's a whole vernacular that's tied to this thing. And when you talk to your educators, sometimes or we see from the other side, these blank looks that people give us because of language. Here are the things that I thought we'd cover tonight. I won't read those, but you can scan them quickly and see what we're going to do. There are a handful of slides, mostly one for each, but several for a couple of others. First of all, the IDEA is not the only law that's applicable. It is the one that we spend most of our time with because it is most prescriptive and most detailed. The IDEA was passed about a year or two after the Rehabilitation Act of 1973, also in more common terms called Section 504. Section 504 basically says if you get federal money, you may not discriminate based on disability. Because you are schools, you get federal money, you may not discriminate. The IDEA adds to that all of the very detailed responsibilities that I'm going to talk to you about in the coming hour, 50 minutes, whatever we have. I heard years ago a really interesting comparison that I think is apt. If the IDEA is a donut, have you heard this too, Mr. Atton? And the Section 504 is the donut hole, one has started to fill the other almost completely. And so even if folks are unsuccessful in claiming rights under the IDEA, which is more prescriptive, they often will then fall back to 504 and say, you need to do for me under 504 what you don't think you have to do under IDEA. So the outer margins of these can become very close, to be honest with you. You all are very familiar with the Americans with Disabilities Act. That impacts employment, places of public congregation, and other issues. Sometimes there are ADA issues that are tacked on to the IDEA and 504. And then within the last couple of years, the General Assembly in Virginia passed sort of a baby constitutional rights law called the Virginia Human Rights Act, which protects persons with disabilities among other protected classes, like persons from other racial and religious minorities, etc. But generally speaking, what we're here to talk about tonight is the IDEA and the federal and state implementing regulations that are attendant to it. So, at one time, and I did not confirm this before coming tonight, but I should have, this was the, believe it or not, the second most litigated federal law, only behind the charges that are brought before the Equal Employment Opportunity Commission. So, federal discrimination employment claims were number one, and IDEA claims were number two. Among those, as you'll see, you saw the reference to a DP hearing. I'll cover that a little bit later. But the way folks who complain under the IDEA can seek relief is through filing what's called a due process request or due process hearing request. And that's a trial-like or trial-light process in front of an administrative law judge, not a black-robed judge. And the law says that a parent specifically complaining under the IDEA has to bring that claim through a due process hearing before advancing it to federal court. It's a term called exhaustion of remedies, exhaustion of administrative remedies. So the IDEA generally contains a whole bunch of procedural and substantive protections, both for students who are deemed eligible as students with disabilities and their parents. And now we start to get into the terms of art. They also, the law requires a substantive benefit, which basically says that local school divisions have to provide what's called a free, appropriate public education, or FAPE. We'll get into that in a few more minutes of what that means. But among the due process complaints that are filed every year that I just referred to, FAPE is the issue that is most litigated. Most of the time it's about, is my baby getting what she needs to appropriately access the educational program that's available to her non-disabled peers. Does all that make sense so far? Okay. So how do we start this process? There is a notion called child find, which means the school division, your administration on your behalf, has to identify everyone in Shenandoah County, every school-aged child and some preschool-aged children, who might have a disability, including those who attend private schools. And so your special ed staff annually has to send out notices and alerts to notify community members of how they can make a referral for child study or child find. And it's very important here. This is one of the challenges I know special educators face, and then when the questions come to us, both regular educators and special educators need to be cognizant of this, because most often, right, a child is in a regular ed classroom might be exhibiting signs of a disability, or mom and dad might come to the regular educator, and she or he needs to know what to do with that information. So some good professional development for the school level administrators and staff is key. And you all have so much abundant free time to get that done, I'm sure. That was supposed to be comedic effect, I'm sorry if it failed. Okay, so they need to recognize how to initiate the child study process, and then we start with some mandated timelines. That referral has to be acted upon within 10 business days. And the regulations are very specific on what a referral looks like, how it has to be handled. I'm not going to get into all that with you all tonight. For your purposes, you just need to know that if a mom or dad or a teacher on behalf of a student says, I suspect a disability, then we're into the deep end of these waters, okay? When asked to evaluate, the educators have to make a decision as to whether or not to initiate the evaluations, and if they decline to do so, they've got to provide what's called prior written notice and explaining why they are going to accept the evaluation or not. This is the first time in a long series of procedures where school officials have to issue this PWN, or prior written notice.
Question for you. How
Please.
often is the referral, how often can you do a referral process?
Hourly if you want to. I mean,
Okay,
I'm
so
being
if-
somewhat facetious, but
All right, so if coming into the school year, we had a referral for services, whatever, and say in 6 months, we're seeing other behaviors, we could have a reevaluate, correct?
you could, I think there is an asterisk caveat there, that let's say the parent made the child available for evaluations, we went through evaluations, we're gonna get through all of this in a few minutes, and the eligibility team says not eligible.
Right,
I think the school division has a right to request that there be some change in circumstances, some new data, maybe an outside evaluation by a third-party provider that we haven't seen yet, but not to just come back and have the same conversation with
no,
the same data.
no, there's other behaviors or something that we may have to go back to the board and say,
Certainly.
you know, there's something else going on here
Yes,
we
ma'am.
need to look at.
Absolutely,
All right,
absolutely.
all right.
It's not a one and done, if that's what you
All right, yes, thank you.
Okay. I've already mentioned that general ed staff is on the ground from the beginning of this. And, you know, again, we implore that building level administrators be encouraging and supportive of the general educators. Most of your special needs children are educated in the general ed classroom with appropriate supports, accommodations, and we're going to talk about what the IEP is, which is the contract, for lack of a better word, between the school division and the family. But most often, special needs kids, let's just say it's a child with a reading impairment or an attentional issue. We might have things going on in the classroom to help that child, and the general educator is equally responsible for implementing that document as any special educator is. There was a time when I would hear special ed administrators complaining that principals just sort of treated special ed as that program that's operated in my building, but I have no responsibility for that. We would hear some comments like that. So that would require sort of some stimulus to make sure that the administration was leading, because this is a federal law, federal mandate. You all get some portion of your money that's attributable, that has to be spent on this, so we need to do it faithfully. Does that all make sense? Okay, so that's why the sort of second sub-bullet says, be aware and faithful to implementation of the classroom accommodations. We then often assign what are called special ed case managers. They often are the ones that, let's say they're responsible either by school or by corridor, however you've got it administratively lined up. They will be aware of all the children who receive IEPs. They will communicate, hopefully, and help train individual educators on what's required for those individual students under the IEPs that we're talking about. And then they will also ensure some students receive what are called related services. That could be speech, occupational therapy, vision, and other things. Clearly those may or may not be provided in the gen ed classroom. There might be what we call pull-out services, or they might go see somebody to get occupational therapy services outside the normal classroom. But the OT might also come into the classroom to see how it's working in the natural educational environment. And the case manager is usually someone that's aware of all of those things and can facilitate coordination and training where necessary. Okay, But back to the original question. We've gone through child find and everyone says, yes, we think that this child has demonstrated learning needs or behavioral needs, occupational needs, whatever, that an evaluation is warranted. What does an evaluation mean? Here's the definition from the regs. They are the collective procedures used in accordance with this law to determine whether a child has a qualifying disability. That would make it a 504 case. But then you've got to get to the next step. If the disability is of the nature and an extent that it warrants special ed and related services. So a lot of times folks will come in with a doctor's note saying, my child has a disability, but if the child, forgive me, but is a straight A student and knocking the park out of SOL testing and otherwise, and there's no indicia that there is a problem in the classroom, that might just be a Section 504 student. An easy example with someone who has a mobility impairment. Intellectually, they're fine. They can get along very well in the classroom. They just need some extra help maybe moving from classroom to classroom. That's probably a 504 student, not a special needs student. I mean, an IDEA special needs student, because that second prong is not satisfied. They don't require special ed. Does that make sense? All right, so the evaluations, as I already said, can be conducted at the request of a parent or the LEA, and then you've got to have what's called informed parental consent. That means they have been advised of all their rights. They've received a document called procedural safeguards, which is about that thick, and there are so many times that the law requires us to give copies to parents that they have long said, many special needs parents who have been in some divisions for a long time, that they could wallpaper their dens with them. But we are required to give them repeatedly. They advise them of all of their rights, including questions like, Randy, you asked, how many times do I get to come back? We have to give them that information. And then we have to get them to sign acknowledging that they're authorizing us to do the evaluations. There are interesting questions. Twice today from 2 different school divisions I got this question. Divorced parent, mom says I want it, dad says I don't. So there are whole kinds of issues like that that we have to deal with all the time. By the way, my answer to that usually is, could the adults please start acting like adults, decide for themselves so that the schools don't get stuck in the middle? I have a big mouth, I apologize. And if you can't get it resolved, how about asking someone in a black robe to decide it? We're here to educate your children however they show up, and that's what we prefer to do rather than reconciling your domestic issues. Sorry, that was a long editorial. Once the referral is made and consent is given, the LEA has to complete the initial evaluation and the eligibility determination within 65 business days. We'll do some math there. That's a good 2.5 to 3 months usually. So if the referral's in September and we don't do it promptly, we're looking at holiday time before we get through it. I will tell you, your educators won't like to hear this, but I'll tell the board, I don't ever want to hear an educator say, well, I've got 65 days to do it. That says to me louder than anything, I don't care about your children. Now, there might be very good reasons. Their school divisions are having a very tough time getting certain related service providers. So if you need an educational, psychoeducational evaluation done, and your school psychologists are way backed up, or if you need to do a hearing test or a speech test, and your only speech provider just resigns suddenly and all that, there's sometimes legitimate reasons, but the timeline is not excused. And so we've got to figure out ways to do that when our resources are a little thin. The timeline can be extended. Let's say a student moved to you all from Rockingham County, as long as we're showing some good faith and we document the why and the where, we can get some extensions then. And we can also get extensions if mom and dad have made the referral and then don't make their child available for the evaluations for some reason. So there are some excusals. Finally, you all are probably familiar with what is known as response to intervention, which is a framework for trying to deliver services to children who have not yet been performing at grade level or in the way we might expect for them to be. If a referral is made, even if a child is in a response to intervention effort, we can't say, wait a minute, we want to wait till response to intervention is exhausted. If the referral is made, we are obligated to continue down the evaluation path, even if we're still doing RTI. Nobody else square on that? Any questions? Okay, let's continue with the evaluations. They have to provide information to determine whether a child is a child with a disability, but then later they're going to inform how we develop the educational program. So even though they are spawned by a need to determine eligibility, later, for instance, I mentioned the psychoeducational, it often will have evidence about how what a child's intellectual ability is and how they're performing as against that intellectual ability. So it might inform us, oh, reading deficiency, we need to write an IEP that addresses those reading deficiencies, right? There are also things like a social history, so if there are problems in the little person's life, mom passed away suddenly last year, there's some anxiety, there's some grief, there's some post-traumatic stress, we'll know about that and we'll be able to write goals later on. So the evaluations are sort of twofold. They include a variety of assessments and strategies, including those that I just mentioned for developmental, functional, and academic reasons, but it's also the first time mom and dad really get to say, hey, these are the things I care about, these are the things I'm concerned about, and we're obligated to include any information they provide. Increasingly, we see some private evaluations and things like that come in along with a request for a referral. Note that all the federal agencies and the courts have routinely said that we can't be forced as a school division to rely solely on what someone outside has written. We are obligated to consider it. And what I would suggest to you is, while those are well informed, they're often informed by a 20-minute visit to a clinical setting, or maybe multiple clinical settings. And even if testing is done there, it's not done in an educational environment. And the headline from the IDEA is that we need to know how your little one is responding to what we're doing in a school setting. So often we find varied stories. Mom and dad say, well, we never see those behaviors at home, and the school folks are having tons of trouble, or quite the opposite. Parents might come and say, you know, I can't get my child to do any homework, et cetera, et cetera, et cetera. And we say, well, when we have these proper supports in place in school, we're seeing your child meet with success. So those are a lot of conversations that are had in IEP meetings. Is that fair, educated? Evaluations have to be conducted by our school personnel or outside personnel that we hire, and we cannot, despite what I just said, tell parents, you go get your own evaluations. We have to do it either through our own staff or with contractors, but we can't put the mandate on parents to satisfy our obligation to evaluate. And then the last is more of a practice tip than anything. Frequently we do, for instance, with children that are on the autism spectrum or other disabilities, there might be a medical diagnosis of ADD or someone on the autism spectrum or something like that. We'll want a release to make sure that we can have thorough conversations with those outside medical providers in case they have information. By the way, I should have said this from the beginning. One of the premier prefaces or predicates of the IDEA is that this is supposed to be a collaborative process, right? The law says we want moms and dads, not stupid lawyers, to be in rooms helping to resolve these things. Unfortunately, as I told you, it has become the most litigated law probably in public schools. And so although it was idealized that way, it has not always worked that way. And as you'll see, the price tag and the benefits have escalated over time. And so that's why we are where we are. All right, so let's say we've done all the evaluations and we're now, reevaluations have to be conducted once every 3 years after initial eligibility. That's called a triennial. But they can be done earlier if the LEA sees something different, Brenda, to your question, right. Or if mom and dad say, wait a minute, we think there are changed circumstances, maybe there's a new medical diagnosis or something else going on. You're free to come back to the table earlier, but you're minimally required to do it every 3 years. And then you say for reevaluation, you see what the team has to do in terms of notice, the reasons thereof, and a right to request an evaluation. That's all more in the procedural safeguards area. Okay, once we've done all the evaluations and we are at the table, in order to have a disability that mandates services under the IDEA, all three of these prongs have to be met. First, they have to meet one of the disabilities that are in the law. Second, that disability has to cause an adverse impact on the child's educational performance. And third, there has to be a determination that the child needs special ed related services as a result of that harm caused or that adverse impact caused. You see the second bullet includes all of the disability categories as they are listed in the Virginia regulations. For instance, there is one called developmentally delayed for early childhood, and there are some, I think, for instance, at one point anyway, certain diagnoses on the autism spectrum required a child to be at a certain age to make sure that there was enough data to support that truly was a manifestation of that disability. And so Virginia has adopted what's called developmentally delayed. I don't think all states do that, but Virginia does. And it's actually an opportunity for us to serve some children that might not otherwise be served.
Question for you, is there, when someone is diagnosed or given one of these disabilities, is this something that carries out for them for the career of their, I mean, is it something that can affect them in a long period of time? I mean, because I sometimes we either overdo something or we sometimes see something that may not be there, the delay kind of a deal. Is there anything there that we should be particularly careful with when we diagnose or when we label somebody with that will stick with them and have adverse effects down the road?
There are so many layers to the answer to that question. First, you're very astute to point out that children are not, right, they're not snapshots. They evolve as we all
Correct.
do. So part of the answer to that question is there's an entire process under the IDEA for withdrawing a child from eligibility. And sometimes there are great fights about that. If we think a child has been marginal, but we elected to serve them to be conservative and make sure they get what they need, but then suddenly they're doing extremely well, the educators might say, hey, you know what, Mom and Dad, it's time to revisit this, but you have to have affirmative consent from the parents to withdraw them. I don't mention this lightly, but there is a process where school divisions can initiate hearings for relief under the law too. There are times when we think a baby is not being served the way he should be. Mom and dad are just sort of disinterested in whatever. We might want to compel due process to initiate, right? The back end can also be true. Or sometimes we get serial requests by families. Nothing we ever offer is enough.
Right.
And we might say, hey, let's go to a hearing just so we have a hearing officer's order that says this is what we prescribe for this child. And that hearing officer's decision would govern, subject to an appeal to federal court. But you get my point. So yes, I think you're absolutely right. Did I answer your question?
You did.
Okay. Written consent is required, again, informed written consent from the parent before we can begin services by determining the child eligible. And the determination is made by a school team. I don't list all the people there, but clearly the parents are listed as foremost among them. And before an evaluation, before an eligibility determination is made, we have to provide all the evaluation instruments to the parents at least 2 days before we're going to convene, so they have time to review them. Okay. Then we finally get to the IEP, which again is the contract between the school division and the family. Here are some quotes, I'll let you read them for yourself, but the gist of them is from different courts across the country. This is the whole game. The IEP is the deal. It's the central mechanism for how we serve children. There are two primary United States Supreme Court cases. The Rowley case, which is from way back, I think in 82-ish time frame, and then the Andrew F. case, which is the first time the U.S. Supreme Court revisited the Rowley test, and I think it was 2016, if I'm not mistaken. The basic test is what's in bold there. A student's IEP must be reasonably calculated to allow the child to make progress appropriate in light of the child's circumstances. And it's the latter half of that that was clarified in Andrew. You will probably have heard people pejoratively say for years under the Rowley standard that the bottom sub-3 bullet, students are not entitled to the best education, but the IEP must be designed to help the student make more than just de minimis progress. We used to always, again, pejoratively, they don't get a Cadillac, they get a Ford, right? The Andrew F. case challenged that. And after a bunch of wrestling, the parents in that case wanted the de minimis standard raised to the Cadillac standard. And the U.S. Supreme Court said, no, that's not going to be the standard either. But we do want you to look at the individual child. That's what the I in IDEA stands for. And so we don't want a one-size-fits-all approach, and you need to look at how this child might advance toward her IEP goals and as against the general curriculum in light of what her unique circumstances are. And we're not going to second guess you as long as you're doing those things. There is another presumption that's in the case law that courts are supposed to defer to the judgment of educators as the ones who are most and best trained to serve this population, to serve any students. Okay? And then the second half of the FAPE component, the free appropriate public education component, is that students have to be educated in the least restrictive environment, which means they should be educated with children without disabilities to the maximum extent appropriate. If you study the history of the IDEA, I think it's fair to say that in its earliest years, the concern was, and the implementing commentary to the law said, if we were educating children with significant disabilities in particular, we often did it in a trailer out back, and who knows what they were actually getting. So the initial push for the law was this: let's get more of our kids included so that they have a horrible word, normalized life and are interacting with their typically developing peers daily. What we've seen in the last 15 or 20 years, particularly with some disability categories, is a push by parents to have their children extracted from public schools and educated at private schools at your cost, because they believe that they can get better specialized educational services for their child. And so often those private day school challenges are litigated very, very heavily, because as you might imagine, often the costs for those are $50,000 to $75,000 a year. And if it is a second grade student, and we expect he's going to be with us, and by the way, I haven't mentioned this, the law applies to students until they graduate or turn 22. So there are some children who will not be on track to get a high school diploma and will be with us till they're 22. And so you can see what the price tag can be. I don't mean that pejoratively, just factually.
Are you finding any cases of students on the back end of that going, okay, with such a broad range of degrees of abilities and, learning curves in a classroom when you mainstream some kids with disabilities all day, or if it's, depending on what the disability is, if it is disrupting to the others in the classroom, if they're not getting the proper services, that you're finding those parents coming back and having issues with, is my kid getting the correct education, the proper education? Because we've got somebody that needs some service here that may not be getting what they need, and is causing some disruption in classrooms.
Okay, so I don't want to paint with a broad brush here at all. Am I aware of circumstances where that is alleged?
Yeah.
Certainly.
Okay.
If there are children that have behavioral issues, we have an obligation that I'm going to get to in a while to develop behavioral supports for those children. Can they be disruptive? Can we have children who absolutely attributable to their disability might engage in flight behaviors, might engage in some physical contact with the children around them?
Right.
What we would hope to do, ideally, is develop a program that educates not only the disabled child to meet his or her needs, but also the classmates. Right? I think that's, again, an idealized program. Does that happen consistently and faithfully? I can't answer that question, yes. In my experience, have I heard complaints from parents about the conduct or interference by special needs children in the classroom? Of course.
Okay. Thank you.
Was that a fair answer?
It is.
Okay, so what about the IEP? It's got to be in effect for each student with a disability at the beginning of each school year, and then the law says the team must meet periodically but not less than annually to determine whether the annual goals are being achieved, to revise it if necessary, and to address A through E. Any lack of expected progress toward the annual goals and the general curriculum, the results of any re-eval that might be conducted, as we've already covered, right? Information about the child that mom and dad bring, anticipated needs of the child, and then any other matters affecting development or implementation of the IEP. And if a parent requests an IEP team meeting, we should respond promptly. And if we decline to, we need to tell them why. and a prior written notice. Sort of to an iteration of the question, Brenda, you asked a few minutes ago. We have cases where families want to meet on an IEP meeting every week. I mean, not exaggerating, but so much.
Wow.
And I think it's fair for us to say we'll meet again a second time, maybe a third time, but unless you're bringing new issues to us, we're not just going to sit around the table, because please remember, IEPs have to be scheduled at a time that's convenient for parents and for educators. Sometimes that's after school hours, so we've got complaints by our employees that they're being held beyond their contract. If it's during the day, what's happening? We're having to pull educators out of classrooms and out of service provision and hire substitutes to fill in while that's going on. So there's a real pragmatic cost to this that gets unwritten in law. So this provision does help school divisions to say, we're going to set reasonable limitations. Yes, we want to develop an appropriate IEP, and yes, we're willing to do it, but I'm not exaggerating when I tell you I'm in federal court right now on a case where we had 36 IEP meetings in about a 6-month period.
Wow.
And it just becomes impossible. Okay? Contents of the IEP, I'll let you read this for yourself, but the 4 primary areas are present level, which describes who the child is, what his or her needs are, academically, behaviorally, functionally. Series of goals, could be as few as 1 or 2 or as many as we see fit. I think our firm cautions to make sure that we don't overdo it, because sometimes goals are extracted from what the curriculum already says. And these are supposed to be able to help young people access the curriculum. But we're not going to import the curriculum into the IEP, right? And we want to also afford educators discretion on how they deliver instruction in their classrooms, being faithful to the next prong, which is the special ed and related services that the child might need. So this will be a series of accommodations. Often we see a child with attentional issues might be seated at the front of the classroom, might have different visual reminders about how to stay on task, might have an accommodation that says he gets to get up and leave the classroom and go to a counselor or something like that if he's having an anxious moment or something like that. Those are the kinds of things that are there. But we're not going to say for math instruction, we might repeat instructions. We might say that the amount of work that has to be completed is reduced by some amount as long as it's demonstrating mastery. Those are the kinds of things that might appear there. And then the final big issue is the placement issue. Okay? I neglected to mention the special ed related services. Again, if a child is receiving speech, occupational therapy, those sorts of things, it will be listed there, and it will be listed by how many minutes they receive. It has to be that definite. Parents get notice of the IEP meeting. That notice has to include the things listed in the second bullet. Who's going to attend, not by name, but by position, the date, time, location, purpose of the meeting. I've already mentioned it has to be at an agreeable date, time, and location. And then the law prescribes who has to attend the IEP meeting. Right out of the gate, the very first members of the IEP team are the parents. There has to be a special ed teacher of the child if the child has special needs. There has to be a general ed teacher unless the child is completely in a separate classroom. Here's a problem that we often get. IEP meetings sometimes are still being conducted in the summertime to meet the annual goal, and nobody can find a regular ed teacher that knows the kid, so the gym teacher shows up. We don't advise that, right? You want someone who is knowledgeable about the child, even if not as much as the special needs teacher, special education teacher, okay? And then you've got to have someone on behalf of the school division who can interpret the instructional implications and evaluation results and knows the resources of the school division and can commit those resources. Parents don't get to tell us who we have there. Likewise, we don't get to tell them. There's a provision that says other persons that the parents or the school division believe have knowledge. There's no basis for us if someone says, I'm going to bring such and such because she knows my son better than anyone. We don't get to ask for a resume. We don't get to ask for service minutes or anything like that. Sometimes Uncle Joe or Aunt Joanna is a lawyer going unnamed. And so we have to be careful about that to make sure that our administrators know to ask that question, because frankly, I think that would be an ethical problem for a lawyer if they misrepresented who they are and in what role they're serving. But that's a little alarmist. Okay, and in some cases, the student must and should be invited. I think it's most appropriate most of the time, unless the child is either intellectually unable to know what's going on or too young to appreciate the gravity. I don't think we need kindergarten, first grade students as a general matter sitting through the meetings. They probably couldn't sit still for it anyway. I know I can't. And by the way, some of these meetings last 4, 5, 6, 7 hours. Some of them last multiple days, right, depending on how graceful folks are acting. And then the last prong is what I said before. Anybody who has special expertise may be invited. The IEP itself, despite those categories I shared with you, should only include those provisions that the school division believes are appropriate. However, and this is why I underlined all of these things, it has to include the concerns of the parents. And sometimes we write things in IEPs where we list them as the concerns of parents, even if the LEA doesn't agree with them. And the prior written notice might be a document for explaining why. We also have to consider and include references to expert reports, whether we follow the recommendations or not. Again, the caveat I provided before, very rarely do the outside providers see the children in the natural educational environment, and so their opinions should be limited by that limitation, if that makes sense. You also have to consider what's called an independent educational evaluation, or an IEE. There are some circumstances where parents can say, I don't like the psychoeducational that you did on my child, I think it's wrong. I want the school division to pay for an IEE on a psychoeducational done by an outside provider. You all are permitted by law to establish criteria so that it's not just simply whimsical. There's great debate right now about what those require. The Office for Civil Rights has come up with some new standards, but in a nutshell, the folks have to be properly credentialed, prices have to be within a market-driven range. There are a couple others that I'm forgetting now, but essentially, if a parent requests that, we have to do the IEE unless we initiate due process to prove that the IEE is not warranted. Most of the time, from an efficiency standpoint alone, it's worth it just to pay for the IEE. And my sensibility is you're either going to find out that they think the same thing that our experts think, or we're going to find out what they disagree with, which gives us an opportunity to take remedial action if we agree with it. And if we disagree with it, we know where we're going to stand if mom and dad complain about us. Does all that make sense? In lawyers' words, it's free discovery. Not free. Less expensive. Sorry about that. Okay. And then at the end of this, as with everything else, we've got to provide a prior written notice that describes what we offered, what the parents requested, and we refused, if anything, regarding the child's education and placement and the FAPE. All right, folks need a coffee break? Okay, there's this thing called extended school year services, ESY. They're provided to certain children beyond the normal school year. They're not limited to summer school, and they should not be described that way. So for instance, some children might require after hours. They might require, if you only run summer school from July 1 to August 10, they might require it for the end of June and the rest of August. They have to be provided, look at the quote in the second bullet, only if a child's IEP team determines on that child's individual basis that services are necessary for the provision of free appropriate public education because the benefits a child gained during the regular school year will be significantly jeopardized if they are not provided. So little guy's making some pretty good progress during the year, but we know based on our history with him that if he has 3 or 4 weeks where there's no organized, regimented, constructive, structured education, then we're probably going to offer ESY. And you see there's even a definition there of significantly jeopardized. You need to consider whether or not he's at a critical point in instruction that an interruption will cause a significant problem, and then obviously you're going to be considering the nature and severity of his disability. Some folks, unfortunately, I guess, this is what prompted this interpretation, have said, we don't do ESY for fill-in-the-blank disability. Cannot do that. You can't also limit the type, amount, or duration. For all children with a learning disability, we give 2 days a week. Cannot do that. Does that make sense? Okay, so that's how we get the program in place. Any questions about IEPs? Okay. I think that this is probably one of the largest misunderstood areas of special ed law. Because people say, the kid has a disability, you just can't discipline them. That's not true, but the converse is also true. You can't just kick them out without doing a little legwork. So let's walk through that if you don't mind. An LEA is required to conduct what's called a manifestation determination review, and this gets tricky, when it's contemplating what the law calls a change in placement, when that student has violated your code of conduct, and if and only if that code of conduct applies to all of your students. I don't usually see where discipline is trying to be imposed on a special needs child where it wouldn't be, but I do think sometimes there's a misunderstanding about whether or not it's a manifestation of the child's disability. I'll talk about that in a minute. So the key word here is, how do I know there's going to be a change in placement? Change in placement is either more than 10 days out at one time. So if the principal is recommending to the school board that Brad's kid gets expelled, absolutely, that's longer than 10 days. Long-term suspended, more than 11 days, absolutely. Short-term suspension, probably not, unless it falls in the second category. If the removal is only for 3 days, but Brad's kid's already been kicked out 4 times this year for 2 or 3 days at a time, and it establishes a pattern of behavior. So if I've engaged in inappropriate, my kid is engaged in inappropriate touching of a little neighbor multiple times during the year, and now we're at day 10, looking at days 11, 12, and 13, crew's going to get together and say, is this a pattern? If it was in September and it was for cussing, and it was in January for insubordination to a teacher, and it's now May and it was for getting in a shoving match with a neighbor, probably not a pattern. But if it was September, October, middle of October, and it's all for putting my hands on someone else, that's probably going to be a pattern. Does that make sense? Either of those is a change in placement. 10 days at a time, more than 10 days at a time, or this pattern analysis. And in each case, the team has to conduct what's called an MDR. So what is an MDR? It's the process by which the school representatives and the parents and relevant members of the IEP team determine whether or not, as the name implies, the conduct that resulted in the code of conduct violation is a manifestation of the student's disability. Did the disability cause it, essentially? The MDR has to be conducted immediately if possible, but no later than 10 school days after the date on which the decision to take the action is made. Another time where we would encourage you not to wait till the 10th day. Because a lot of things have to happen, especially if the recommendation is coming to the school board. The MDR determination has to be made in advance of imposing any discipline. Okay? It's made by reviewing all relevant information in the student's file, including the student's IEP, any teacher observations, and once again, anything that mom and dad had to say about what's going on. Couple of cautions here. The student's file means the student's file. So if we've had cases where current teachers say, well, we had no idea, this doesn't look like Brad's kid had never engaged in this behavior before, but the historic files show that 2 years ago he was doing the exact same thing, and we had behavioral intervention plans in place then, wasn't communicated effectively internally, so we go up the line, right? The law says you have to look at the entire student file. Any relevant information provided by parents. In my experience, it is rare that a parent was in the school that witnessed the underlying behavior. So this is not necessarily an opportunity for the parents to argue about what did or did not happen, although they likely will try. The better place for that to happen probably is if it is not a manifestation of disability and we impose discipline, and then it comes to you all as a school board, mom and dad get their opportunity to say what they want to say to you about why it should not be imposed. Does that make sense? All right, so the ultimate question, when is conduct considered to be a manifestation of his or her disability? Lawyers love this next phrase. If the conduct in question was caused by or had a direct and substantial relationship to the student's disability. Does anybody know what a direct and substantial relationship to a disability is? Right? That's why moms and dads hire lawyers, and that's why school divisions hire lawyers. Relying hopefully on the good judgment of the educators who know the children the best. That sounded horribly pejorative again, but you get my point. That is the more difficult and the more challenging and the usually litigated question, because there is a right for parents to challenge an MDR determination, and that's done on an expedited basis, as is any discipline of their child, because their child's being removed from the natural educational setting in either of these instances. The other way it can be considered a manifestation of the disability, meaning the misconduct, is if we weren't doing our job. If there's an IEP that has behavioral goals and or accommodations and or a behavioral intervention plan, and it's clear that we were not providing the child those services, then a parent can prove to the MDR team, and the team would have to say, our fault. And if it is our fault, as you'll see from an upcoming slide, then we may not impose discipline. We have to do other things, but we can't impose discipline. Okay, if the team determines the child, as I was just saying, the child's behavior was a manifestation, the team shall immediately return the child to the placement from which he was removed. Unless mom and dad also agree, this isn't working out, what we're trying here isn't working, let's get the IEP team back together and agree on something different. That might mean, for instance, a removal from a gen ed classroom to something a little more restrictive, but you have to have parental consent to do that. It might also be reworking the behavioral intervention plan if it has been non-existent or weak, okay? The other time you can actually remove a child to a different setting is if they have engaged in the conduct listed in that second green bullet. Use, possession, or distribution of weapons or drugs, or if the student has inflicted serious bodily injury on another person. This is one area where I just think the law gets it so wrong. Not that the removal should occur, but the definition of serious bodily injury, I kid you not, is so extreme, it's almost near death. It requires serious disfigurement, a definition of pain that I'm not remembering off the top of my head, but would almost be impossible for school divisions to prove or disprove. So we usually only see this imposed when kids have been involved in drug and weapon infractions. So even if there's a brutal fight, there probably has not been disfigurement, and you all might say, and the principals might say, I got to get this kid out of here. It's not always that easy, and this 45-day for serious bodily injury probably is not going to get you there. Okay, back to if it was a manifestation, we know we've returned the child to the classroom, we're reevaluating the IEP, but we also have to conduct a functional behavioral assessment if one has not previously been done, and then we've got to either develop or refine an attendant behavioral intervention plan, which is sort of part of the IEP, but kind of an appendix to it, for lack of a better word. On the other hand, if the team determines that it was not a manifestation of the disability, school folks can apply the relevant disciplinary procedure, including making a recommendation to you all on the board, in the same manner that you would, and for the same duration as you would, for typically developing children or children without disabilities. However, while the normal discipline can be imposed, you all have an obligation to provide services to children with disabilities to allow them to continue progressing toward the general education curriculum and their IEP goals after day 10. So you sort of get a free 10 days, but after that, you've got to provide services. And the IEP team gets back together and makes that determination. And here's the first pointed comment of the night. which feels very difficult for you all as board members, y'all don't get a vote. And that feels really, really strange because you have all the responsibility. You have to make sure that positions are properly funded and that all of your employees are being faithful to the IDEA. But you all are not members of the IEP team. And so because of that, when it comes to this phase, you are not involved in even determining how that child's going to be served. There are times when I have seen, and Ms. Shepherd, I'm not sure if you all do this here, there are times when a principal may say, this was a disciplinary infraction that could warrant long-term suspension or expulsion. However, there's this mechanism where we can send children to alternative placements. We think that's right. A principal and IEP team could say, we recommend an alternative placement when the disciplinary matter comes to you all, but it's going to have to come back to the IEP team to make that final call and to develop all the supports and recommendations for that. But that might be a way to send a signal to the school board, hey, we realize that it's not being successful in the building, and I'm not well familiar enough with your alternative programs, there may not be that many options. But that's something that I've seen work in some school divisions. Okay, the team has to develop an interim IEP at the MDR meeting and consider an agreed upon IEP that calls for a change in placement to an alternative for discipline like I just described. And then I've said all along that disputes over the MDR, the discipline itself, the pattern analysis, and any alternative placements can result in a real quick due process hearing. I kind of flew through that. Do you want me to pause for a minute and see if there are any questions on discipline?
So who makes the final call on an IEP if we remove a child or if we don't? I mean, is that a collective of the team or is that a collective of, I mean, if there's 7 on the team, do we put it out for vote? I mean, who gets the final say to say, yeah, Matt, this is just not where this is.
The law requires that the team reach quote unquote consensus. And that's at every step of the way for the original IEP development, for any revisions to the IEP, and on an MDR. At each step, parents have a right to initiate due process. So their relief, if they feel, like I've never been in a meeting where everyone said, raise your hand if you agree, don't. Each participant in the IEP team meeting or the MDR meeting has an opportunity to file a contrary opinion or a dissenting opinion, including the parents. And so there is space for them to do that. So if the administrator in the room says, I hear the room saying A, I hear a dissenting voice saying B, we're going to proceed under A, we're going to allow B to be documented as a dissenting or contrary opinion, and mom and dad, here are your procedural safeguards, explore them to find out how you can seek the relief you want. Okay?
We won't get into the Honig injunction.
No.
I had to talk to.
You want me to?
Yeah. I think that goes a little too far. On certain cases, we have to do that.
Yeah.
And I
If
know
a kid is
we're not
particularly
talking
dangerous, there's an old case called Honig versus whatever school division. We could run straight to court. If we believed a child was so violent or so self-harming, for instance, that he or she was creating a danger to himself, we can run to court. I can't remember the last time one of those was done. Usually we try to do an expedited hearing. Sometimes, increasingly I would say, there are cases where the objects of that violent behavior have filed criminal charges. So the little person's involved in the court system while we're trying to figure out educationally. Sometimes we can have civil conversations with mom and dad to say, look, you got bigger issues. We have no control over what the juvenile and domestic relations judge is going to do. How about we put your child in a safer environment, a home-based environment with some supports or something like that, at least while the criminal proceedings are pending, so that your child's not the object of some copycat allegations or subjected to the same stimulus that caused the problem to begin with. Not always successful, but that's a softer skill that some of folks have to try to reconcile those differences. Okay. According to guidance from the U.S. Department of Education, just as a side note, we've been doing IDEA for the last hour. 504 has very similar provisions. They're not quite as detailed, but they also get an MDR. So again, these are children with 504 plans, but not IEPs. And remember, a 504 plan does not include related services, does not include the same intricate goals and sub-goals and things like that, special ed related services. But there are certain provisions in a 504 plan. So they get an MDR. The educational services are provided to the same extent provided to students without disabilities during disciplinary removals. So if you would normally send your general ed children to an alternative setting, you would need to do the same thing for a 504 child. And a Section 504 hearing, they're entitled to a hearing to challenge the decisions. And that's true for all offenses except as under the ADA, Americans with Disabilities Act, for drugs and alcohol cases. They do not enjoy protection under those acts for possession or distribution of drugs. All right, so if none of this has gone well and we're in disagreement between the educators and the family, what can happen? One option is mediation, and VDOE has a very fulsome, neutral mediation process. It's free to the school division and the parents. However, both parties have to volunteer. It is confidential, and nothing that happens there can later be admitted into any proceedings unless we get to a signed mediation agreement and then one or the other party breaches that agreement, then that can be enforceable. But we don't get to go in, we mediate for a couple of days and that's not successful, we end up in front of a due process hearing officer. We can't say, well, Mom, you said during mediation you would agree to X, Y, and Z, and Mom can't say to us, you promised me X, Y, and Z. Okay? Does allow the parties to resolve disputes in a less formal environment to avoid the cost and distraction of litigation. Sometimes neutral mediators are very good at that. And there's no obligation that at the end of the day we come up with an agreement, but we're hopeful that it will be. Parents, individuals, and organizations can file state complaints with the VDOE. They have an entire department that fields them. The complaint has to include facts and alleged violations of the law. VDOE provides us notice with the complaint when it comes in. We work with your special educators to file a response. Sometimes they come on site to do investigations. That's rare. They usually just take the submissions of the parties. If they find that violations have occurred, they can order some remedies, such as directing that the IEP team reconvene to determine if a child's IEP is appropriate and if there were, for instance, missed services, whether a child should receive what's called compensatory services, makeup services, for a failure on the school division's part. If none of that works, we can, and by the way, they can file a VDOE complaint and a due process hearing request at the same time. If they are both on the same issues, one can be held in abeyance while the other is proceeding. Due process hearings can cover anything regarding the provision of FAPE to a child, including identification, evaluation, placement, and services. Most hearings involve whether or not the child is receiving FAPE and or what the placement should be, and as I told you before, increasingly they relate to private reimbursement requests from families. And so relief can be compensatory ed, tuition reimbursement, or directions to revise the IEP. Notably, Mom and Dad don't get money. They can't come in and say, I've been harmed, like in a personal injury case, I want $200,000 in punitive damages. There is no money that changes hands except to another educational provider on behalf of the child. Sometimes if a family has, for instance, gotten private speech services, and if someone believes that the child, the hearing officer says, school, you should have been providing that, we might have to reimburse Mom and Dad for that out-of-pocket expense. But we don't write them a check for anything that they might have done. And then, this is one of the incentives for parents, they get attorney's fees if they are what's called the prevailing party. But a due process hearing officer can't award that. So a hearing officer could gavel down saying, Shenandoah County Public Schools, you did everything wrong, I find this IEP non-compliant for the following reasons, and I award the following. And if they've got name the law firm of choice from around here that represented the family, and the lawyer says, I want $100,000 in fees, the parents can't get that without requesting it of a court to award it. The court then reviews what happens and makes a separate determination on fees. But as you can see, right, the bill could run up, because if you were to lose, had you hired us or another firm to represent you in the proceedings, you got our cost, you have to split the cost with the family of the hearing officer and the court reporter, and now if you lose, you could be on the hook for attorney's fees for the family. Okay, we're getting close to the end. You've probably heard a lot about restraint and seclusion in recent years. So the Virginia Commission on Youth, more than a decade ago, conducted a study, and then the VDOE came up based on those commission's recommendations with some guidelines and some promulgated regulations that basically highlighted staff training on when and restraint and seclusion should be used and how staff should report those incidents to families when they occurred. Later, the Virginia General Assembly in 2015 passed the law that's on the screen there, and it basically says, hey, VDOE, you need to develop the guidelines that you kind of had already been developing, but we want it official. They're based not only on the previous VDOE's guidelines, but on 15 principles that the United States Department of Education had put together on restraint and seclusion. You see there some of the details that are included. Obviously the concern is that we're not physically restraining children in a way that's harmful to them, or isolating them, putting them in dangerous conditions behind locked doors with no windows and nobody monitoring them. Okay? The bottom bullet is important. The board has to specifically identify and prohibit the use of any method of restraint that poses a significant danger to the student, and establish safety standards for seclusion. They also have to acknowledge the distinction between restraint and seclusion for general ed populations and special needs populations, and also younger children versus older children. So finally, we get to what is your job? Maybe not as much as you would like. I'm sure that you all as individual board members field questions from maybe educators, but certainly parents as well, about individual cases. My encouragement to you all would be to redirect those to the educators that are properly responsible for handling it. You all are policymakers, so you have to make decisions about budgets that might impact your special needs program. I'm sure as part of Ms. Shepard's pending budget request to you, you see a lot of information about that. But this is important. No individual decision about a child can be made because of how much something costs. It cannot be discussed at all by an IEP team. If the child needs it, we're obligated by law to pay for it. And then again, I said here, you all are not a member of the IEP team, so you don't have any role, as uncomfortable as that might feel, in determining what's appropriate for an individual child. And we said here, Congress determined that those decisions should be made by trained educators. There are also, and I want to elaborate on this, but there could be some privacy concerns that you all don't have a need to know until you have a need to know. And for instance, you don't just routinely walk into a school and pick up an employee's file or a student's file and rifle through it. So there'd be no reason for you to do so here. But all of that being said, as I've iterated several times tonight, the IEP is a contract, and you all are responsible for making sure that the people on the ground are being faithful to those contracts. Last slide, you do have the authority to make programmatic decisions, which could impact the educational services that you're providing, staffing to meet those needs, maybe relationships with outside vendors if you don't have the ability to do it internally. Okay, and then I made a bullet here that you all have, by law, you're required to have a special ed advisory committee. And clearly we would encourage you to have open dialogue with them about what they're expressing. And then you get to call us if you want to. After tonight, you may not want to. Okay. Mr. Chairman, that's all I got in this.
Question for Mr. King?
We're gonna get a
You
copy
don't
of
need to
that?
see that anymore.
Are we
What's
gonna
that?
get a copy of that?
Glad to, yeah. I'll just leave what I have, and you can run photocopies, or you can run it off. the
I'll
computer.
have it.
Yeah,
Yes,
she's got it.
absolutely.
I think the first presentation that I saw you do was on Andrew.
Oh, is that right?
Yeah, it hadn't
Did I say
quite
the same
been
thing to you?
decided yet. I don't remember. I was new on the board, but I specifically remember that name because it sounds like Andrew, you know? So, yeah, that was a while ago.
Since we came out of the pandemic, how has that affected our special ed students? I would assume it'd be worse than the regular students, or have we got caught up yet? Who like?
I think there's more impact just because a lot of our students, the disabilities that they have, the understanding, and some of the mental health pieces that go along with that it's impacted them. I also think that our general education students are impacted. We're seeing a lot of our general education students that may not be identified with a disability, but are struggling with some of the same mental health issues and some of the same concerns. So,
Do we have a lot of students who qualify for ESY services? Or is it
we're
a pretty
just
small
starting
group?
our ESY, going back, looking and reviewing IEPs to see if students qualify. We have criteria sheet. We've just developed all of those criteria sheets, looking at that to make sure that we are going to service students that need the ESY.
Well, thank you for all the information.
Thank you.
There is no way, the staff has got to deal with this. I mean, it's amazing. You know what, I know what the law is, and to implement the law and keep it, all parties involved. I remember when I was an educator, I sat in on some IEP meetings, but I don't think I ever had one that taught middle school that we had a student sit in on his or her IEP. I do not remember that.
One thing that I didn't mention is by 16, you've got to have a discussion about transitional services, meaning what's the young person's life going to look like beyond high school. And it's mandated that they be consulted then.
Okay.
Doesn't necessarily mean they have to come to the table, but they have to have been surveyed in a number of ways about what their interests and affinities are.
Okay, thank you. Have a safe trip home.
Thank you. Good seeing you all.
Thank you.
Proceeding, student behavior, 3-2, Ms. Shepherd.
Yes, first I would like to thank Mr. Taylor for helping us with the comfort of the room. So he turned up the air condition for us. So
Running the air conditioning in February.
yes.
It's crazy.
So over the last few months, we have heard concerns about student behavior and discipline. And tonight we actually have a few experts with us who will talk about student behavior and about their processes for behavior, consequences, and discipline. So we'll start. We have one principal here from each of the campuses and one from each level. So we'll go ahead and start with Mountain View High School Principal, Mr. Dorman.
Thank you, Chairman, thank you. Well, I guess discipline, and everybody has their own style, and I don't think there's any one right way to get to the end when you do your building. You know, my style is probably very different than others, but it doesn't mean, you know, you don't come to the same conclusions of how you do some of the stuff. For one, as a principal, administrator, you set the culture in your building. That's first and foremost. That is your job. And you do that in a number of ways. One, first and foremost, and this is paramount with this one, is you build relationships. I can't tell you how many tough situations that helps you get through with kids and parents because you have a relationship with them. And discipline isn't about punishment. And no matter what you say, you get this punishment, that punishment. It's about changing behavior. That's the ultimate goal of discipline. Not about how many days of ISS, OSS you get, but you ultimately want to change that behavior. And building relationships helps you get to that point, but also, you know, with staff, expectations of what you want out of discipline in your building and what your non-negotiables are going to be. And, you know, from a veteran staff, those expectations, you know, we talk about them all the time. You know, faculty meetings, definitely beginning of the year, obviously. But even with veterans, that takes routine maintenance. And that happens in a number of ways. First, you model it every day. You're out, whether it's your walkthroughs, whether it's when you're introducing or welcoming the kids in the building, you're walking through each classroom each morning or afternoon, you're out at bus, you know, dismissal, or you're in the lunchroom where you need to be. You're modeling that and you're doing that and you're showing your staff. And your staff understands what your expectations are. And, you know, but you still need to show them, and like I said, maintenance all the time. Because everybody slides. It's just like the old farm truck, Marty. You know, we get there, but it takes maintenance, routine maintenance. And, you know, that's what you do for your veterans. Now, your new folks are a little different. You know, when they come in as new staff, I don't, you know, they get a gloss over in the regular faculty meeting, you know, the maintenance part for your veteran staff. But I pull them aside and we sit down and have just a small intimate meeting because they're not going to want to ask questions about how, and that's where a lot of your new staff, that's where their concerns are, discipline. So you sit down with them in a small meeting before school too, you know, usually before your regular faculty meeting. And you go through that, and they ask lots of questions about this one. What if I do this? What if I do that? And, excuse me. And I pretty much tell them, here's where our non-negotiables are. You know, I will deal with kid stuff, and I expect you to handle discipline in your classroom, but we're not dealing with the disrespect. You know, that's where I expect you to put your foot down. And when you've used the tools in your classroom to try to handle the behavior and you need assistance, then you give us a shout. Because I need you to focus on the 20 other kids in that classroom, and I'll help you with the discipline or one of the assistants. You know, so when you've done that and you can assure that you've done that, you've communicated to parents and you've done your part, we're going to be right there to help you. So that's what you kind of have to assure and coach up your new ones, because they need to hear it more so than your vets. Your vets need to hear it, just not near as much. Then with my new folks, it's even more maintenance. You're popping in with them. You know, I know we're supposed to have new teacher meetings, you know, once a month, but honestly, guys, that probably should happen more often than that. And it happens for me more informally. I'm lucky I don't have a lot of turnover. And that's almost on a, you know, every other day I'm going in classrooms. Ms. Tusing, you good? Give me the thumbs up. And you can look in those new teachers' eyes. You know when they need help. So you'll roll, you know, circle back around, or you see, you know, if they're upset or something's bothering them, and you come back in their planning period. Hey, you okay? What's going on? And that takes, you know, a lot of your time, but that's what needs to happen to get them where you need them to be, and so they feel supported, just like your regular staff. And then ultimately your new staff come in and they become your veterans, or they, you know, become ingrained in the culture of your building as well, but that's how you do it. And it takes a lot of work, guys. I'm just going to be honest with you. It takes a lot of work on an administrator's part. I know, you know, the nature of our job pulls us into our office quite a bit, but you got to work and you got to get out there, because that's where the action happens, in the halls, in the lunchroom, and in those classrooms. And that's where you support your staff. And that's what has to happen. So, you know, you're out in the building, you know, part of that maintenance is you're doing your walkthroughs, morning, after school, during lunch, class exchange, all those times. Because staff, just like the kids, become creatures of habit. And they know, I can just trust me, they know when the littlest bit is off. Because just from starting the morning announcements, you can kind of tell if I'm not doing announcements. And I come back from a meeting, hey, where were you today? We didn't hear you do announcements. And you can kind of sometimes see an uptick when just, you know, their routines change in some of the behavior. So anyway, that's as an administrator, at least for me and my style of, you know how we handle it at the high school, or at least Mountain View. And like I said, everybody has their own style, but that's how we kind of try to tackle it. So any questions from folks about at least high school level or Mountain View?
Mike, how many students do you have with the 8th grade there?
630 to 625 as of today.
Dr. Rusher from Signal Knob.
So I brought some handouts that really goes through kind of what we do throughout the school year from the very beginning. And just like Mike said, it starts with relationship building, setting expectations, and constantly going back to those things. So we start off the school year, when you open your packet, you'll see a colored, looks like Legos. That was our theme this year, of being together. And we do a assembly with our kids by grade level that talks about expectations. So we go over expectations everywhere in the building. And you'll see in the bottom corner, there's a little matrix. And we go over, like, what does behavior look like in the bathroom? What does it look like in the hallway? What does it look like every place they're supposed to be in the building? And we talk about that. We go over parts of the handbook with them during that. So just everything with our kids, let them ask questions, but we do that the very first week of school. Teachers revisit that frequently, because like Mike said, it's all about maintenance, and especially with middle school students, it's a constant reminder of, you know, what did we just talk about yesterday. We do a whole grade level assembly twice a year. We do it at the beginning, and then we do it again at the beginning of the next semester. Again, just as a refresher. But then we also go into classrooms as needed. So if, like, let's say Mike's class was having a particular issue, we'll go in and address just that maybe behavior issue or that concern maybe that class is having. So we do that with our students at the very beginning. And then you'll also see in there, we communicate with parents. I send a newsletter home once a month, and we'll highlight things. But this year, we also sent home with parents for every student a behavior expectation.
that parents and students signed and returned. So parents knew exactly what we were expecting, as did the students. So it was an agreed upon, and it was the same for the entire building. So we sent that home this year, just again, so that our communication of what we were expecting behavior-wise was for everyone. We spent a lot of time over the summer putting together a handbook for our staff, kind of talking about that RTI, or that tiered process, like what are tiered behaviors, to help them understand better what are classroom managed behaviors versus what are office managed behaviors. And again, you can look at it at your leisure, because there's a lot of information in there, but it'll have examples on what are things that are tiered, and it also gives teachers ideas of how to handle those behaviors. Because again, it's, I'm lucky too, I have a very veteran staff, but it's, kids are different. Mr. Helsley mentioned since the pandemic, what our kids came back to school with after the pandemic in terms of behaviors are a little different because of their mental health. So teachers need new tools in their toolkit. So we spend time working with our teachers and giving them new tools that they can use to deal with different behaviors that maybe they didn't see before, or didn't maybe see as much as before. So we do that during faculty meetings. I do that during grade level meetings. I meet with my grade levels once a week. And if they have a certain discipline issue they want to talk about, or behavior concern, we do that during those meetings as well. And then week before last, we participated in the Virginia Kindness Week, and we're carrying that for the remainder of the year. So you'll see in your packet also, every kid took a kindness pledge and signed a kindness thing, because again, we're trying to emphasize behaviors with our kids and how to be respectful and kind to each other. So the whole school did a kindness pledge. You'll see a sheet in there of all the kindness activities that we did over the last week. Again, just promoting kindness. And then we had Savannah Miller from Response did an assembly with all of our students on kindness and empathy, because again, that's an area I think that our students are kind of missing right now. So we did a focus on that as well. And in terms of kind of like Mike was saying too, there is really no black and white with like consequences, because there are just so many different layers when you're dealing with children. As our presenter said, you're talking about sometimes students with special needs, so they have to be dealt with slightly different in terms of what do those consequences look like. So every kid is treated as an individual, but we do follow like our, the consequences that are in the handbook. But it's really important at the middle school level too, that we're educating our kids and we're teaching them. We want them to have better behavior so that when they go out into the community, into the world, they're more responsible. So it can't just be a consequence. It's how are we teaching them and helping them make better choices along the way also. So any questions? And as you look through that later on, if you have questions, please feel free to ask me. I'll be happy to answer anything, but felt like at least you had all the resources that my staff has at your disposal for that.
Thank you.
I think it's my turn.
Yes, Dr. Shawn?
So I can kind of say ditto to a lot of the things that Dr. Rusher mentioned. So of course we have our student handbook, which parents sign off that they have read that. That includes the code of conduct. It includes our expectations as far as student discipline. But what we know is that But what we know is that parents don't always read the handbook. So thinking about moving forward from this conversation, we have planned for next year to not just do a regular open house on open house night, but then back in the old days, we had each grade level come in on a different day at a different time, and we had them sit in the cafegimatorium, and we explained attendance, discipline, all of those things. And I think we've gotten away from that, the pandemic, and also our new open house model. So that's something that we're going to reinitiate this coming year. But as far as those student expectations, these kids are, some of them in school for the very first time. They don't necessarily come with all of the skills to know how to behave, how to sit still, how to share, how to use their words. And so we see so much of our discipline as teaching. We have school-wide expectations, and it's a matrix, similar to what Dr. Rusher talked about, that talks about every setting in our building, and then what the expectations are for being respectful, responsible, considerate. I'm gonna get them along. There's a, yes, but we have our vision and our motto that we talk about every day on the morning announcements. But then they're posted in every classroom, and then they're also posted in the hallway, like outside the bathroom. So there are visuals for our little people and words for our not so little people. In regards to students with behaviors, as Dr. Rusher said, you just never know what a student might do. And it's not black and white, because a lot of the things that she said, and so a lot of times teachers will try to solve a lot of problems in their classroom, and we don't necessarily know how consistent those problems are. So doing more, talking at grade level meetings about we call them our high flyers. So who are the kids that are giving you the hardest time? What does that look like? Involving our behavior, our BCBA person in those conversations, involving our counselors when we need to, and really pooling our resources so that teachers are getting that support prior to them feeling like they've had a student that we've gone too far. So I think there's got to be lessons, because a lot of these kids don't really know how to behave yet, but there are also consequences to those behaviors, because those students need to learn that there's behavior that's not acceptable. Any questions?
Questions, colleagues?
Well, Brad said earlier, he used a term that I think applies to discipline that I didn't know. Social anxieties, and that's when you guys talk about case-by-case basis and each child is an individual. You all are the ones who know what's going on at home, usually. You know if the mom just died, or, you know why a kid is exhibiting behaviors for the most part. So that's why there has to be a little bit of flexibility in how discipline is approached, especially with the youngest kids, I think. There's no way for somebody who is not right there with them in the school to know what the proper consequence is. I think the principals have a lot on their plates because they're the ones who know the kids. So I appreciate what you guys do. It's not easy. And Mike, I see the respect you get from your kids because you know every single one of them. And I've always been really, really impressed by that. The very first time I visited your school.
Tough conversations a little easier sometimes.
Yeah, you knew every kid by name, every kid addresses you. I really appreciate that.
Thank you.
Yes, I agree with Cindy, and I know my colleagues agree. Y'all got a big responsibility. And let's see it this week. Thank you for honoring us on School Board Appreciation. We ate well. And I think the Northern Campus is tomorrow?
It was
anyway.
Today.
Oh, it was today, anyway.
And we had to reschedule because I couldn't make it and Andrew was sick, so.
Okay, but anyway. You could see it firsthand. And I know something, the kids that cause you divorce trouble, I taught, it may be a handful, and you spend 90% of your time dealing with them, but the 90% that knows how to behave, they're doing their job, representing each school appropriately in the community. That's what it's all about. And I have one question. I've been out, I don't know how many years I've been out. Do we still have the pledge and a moment of silence by state law?
Yes, sir.
Okay, that's good to know. That was a good law, and I'm glad it's carried on. Any other questions? All right, yes, Dennis.
Yeah. So I have a concern. So you both mentioned that there's no just black or white and every student is an individual. That gives me a concern because it seems to me we want to have a system where kind of know it, and you know what's right and what's wrong, what's expected, what's not expected, what's tolerated, what's not, and where you feel that your boundaries are the same as other people's boundaries, and that you can pretty much set your standards of behavior personally as a, within that. And yeah, we all have individual differences, but we have the same laws and the same speed limits and the same consequences when we show up before the judge. And I'm just concerned that if that philosophy that I'm an existentialist. I believe in individualism more than anything, but in a society, it seems to me that there's got to be pretty much of an indication of what's right, what's wrong, what's tolerated, what's not, and that we all know that at any age that these students need boundaries to stretch against, and they're going to various degrees. But those boundaries have to be pretty much set, and that's my philosophy, and so that somebody fairly soon in a school setting knows what's tolerated and what's not, and if they do something, they're not going to be treated differently from somebody else. And so that would give me, as a student, a feeling of insecurity or unsure where I am, what's tolerated, what will you tolerate from me that you're not going to tolerate from somebody else, or what? So that would cause some real confusion for me, especially at the elementary level. And I understand some of those differences even at the high school level, but still, that's a concern I have after having heard your presentations.
So for me, if I can just clarify,
Sure.
I guess, so the expectations are the same, and the consequences could be the same, but how I kind of to your point, Ms. Walsh, how I interact with the kid and what that kind of conversation and the length of time that takes could be different. Where it could be a conversation with Mike, because Mike and I have had this conversation and we are cut and dry. But maybe Robin, I know I've got to spend a lot more time helping her process what has happened and what those consequences are going to be. Where Mike, I might have done it in 2 minutes, it may take me an hour to get Robin to that same place of understanding that this was the expectation, these are the consequences that you're going to have. So that's kind of what I mean in terms of it looks different. That process of how I get from A to B looks different for every kid because, again, of what they might be bringing to the table. The consequence is going to be the same. The process looks a little different.
I understand. Actually, that makes a great deal of sense, and that is when there's a transgression, then there is some degree of appreciation for where that came from. Not necessarily that the consequences are going to be different, but that the way that you change that behavior in the future is going to be mitigated by the circumstances of the environment and the development and the stage that student is in. So that part of it makes sense to me. Okay.
Well, and I'll say, like, a 5-year-old, how we handle that conversation and all of that, and the fact that they may not understand because they're 5 and it's their first time in a setting versus a 5th grader with the same infraction, like that's where that kind of gray comes in, because we're trying to teach all kids that the way we treat one another is really important, and then also like that in real life, if you make a poor choice, there's a consequence. If I speed, if I get caught, I'm gonna get a ticket. And so, but when they're little, there needs to be even more of that teaching, learning opportunity because they don't necessarily know. And they may not have that kind of teaching at home. So that's important.
I usually find that teachers work miracles in classroom for kids that don't have structure at home. I can remember walking into Sandy Hook one day with my first grader, and I had spent some time in the lunchroom and I had heard the stories. And I walk in one morning and I asked this teacher, I said, what'd you do, pass out Ritalin and get the whips out? I mean, seriously, what did you do to, because they were a wild bunch. But what I know is having kids, even at the youngest of ages, 2, 3, you can't hit me, no. They understand that kind of deal, and sometimes behaviors at school are far more under control because of the consistent expectations where mom, you know, oh my gosh, he's so cute, he looks just like me, and he's so sweet, how can I be so mean to him as to put him in the corner for 5 minutes? You know, that kind of a deal. You know, my concern is those expectations. I can appreciate for sure that we sometimes may need to spend longer time or season the conversation with someone who may be a little tender or whatever. But as long as those expectations are carried out at the back end of things, you know, where you have second graders who are sitting there trying to do well, no daggone well if they wallop the teacher or through a chair, mom would be called and there would be some problems. Whereas we may have students that, well, you know, we kind of accept those behaviors if it becomes a normal thing. So, you know, for me, it's about consistency on the back end. We do have a student conduct, you know, following those and understanding they're there not only to keep that kid safe, but the 20 other in the classroom as well as our teacher. Like I said, we don't have teachers just running into Shenandoah County and filling out applications to come teach for us. So we want to protect them as well. So I appreciate you coming in. Thank you, Mike.
Thank you all. Okay, proceeding to 3.3, the draft of the GAR regulation proposed changed by Dr. Heingardner.
Yes, if you look at that compensation policy, it's actually a regulation. We want to make an edit to that, and so wanted you to see that this evening. If you scroll to the bottom of that sheet, you'll see where it's highlighted. The yellow highlight is just to draw your attention to some important pieces that are already in this regulation. But then the struck through is obviously what we're proposing to take out, and then the red is what we're proposing to add. As we get into this place where we are with needing to help in various ways with filling positions and so forth, this has become a little bit of a need, and so we wanted to try and make it very clear as we move forward, and we may have these needs in the future. We know exactly how folks will be compensated. It's not a how are we going to pay them question. We know this is what it is. It's in our policy. Everyone's treated the same thereafter, and so that's what we have are proposing that you would approve at our next meeting with regards to that. Any questions around that? It's pretty small, pretty minor change, but wanted to make sure that you were aware of it.
So if there's no disagreement, I can actually approve a regulation. I just need to let you guys know. So we wouldn't even have to see it at the next school board meeting unless you guys have concerns with what we've proposed. And that is an acting assistant principal will be paid an additional $40 per day, and an acting principal will be paid an additional $75 per day for the duration of the assignment. And we have several of those currently, and they are doing a phenomenal job. And I can tell you, if you divided that $75 a day by the number of hours that our acting principal is putting in, it's probably a few cents on the hour.
Questions? And obviously you've done this because of the need that we've had at the beginning of the school year.
We've had 3 acting assistant principals and 1 acting principal so far this year.
Okay. Since I hear no more questions, thank you, Dr. Heingardner. And going to 3.4, the Shenandoah County Public Schools Social Media Code of Conduct for Employees. This should be interesting.
Well, It's really not that big of a thing. This is something that we had a number of years ago, and I think the time at the time it was felt it was kind of outdated and not really necessary, and so we kind of scrapped it. However, you know, things change, and we believe that we need this regulation back. And it has gotten good scrutiny through our technology department. Tim and Doug have gone through it quite a bit to make sure that it would be up to date and applicable for our needs. And so we believe this would be good guidance to put back into our policy manual to give guidance, just as it says, to our employees as well as our student groups. You know, like a good example is FCCLA. They may use a website or a social media app to send out information, obviously. And we need to have some rules and regulations about how that's supposed to work. And so that's really what this is about. It would be the entire regulation being we're proposing that be put back into policy manual.
Questions? Has the employees seen this guidelines?
I don't believe it. We have shared this out. No.
Can we send that out somehow and get feedback from them? Or I don't want them to be blindsided. Colleagues?
I'm fine with if you want to put it out. I don't have a problem with it.
Or the principals can do that at each school level.
We can find a process to do that. That's not a problem.
And where did you I can't hear one of my flaws. But anyway, where did you get these guidelines from?
These were originally VSBA provided guidelines around policy GAB.
Okay.
Okay. And like I said, a couple of years ago, VSBA stopped updating regulations, and we kind of felt like it wasn't necessary to continue to have these. But again, over the past year or so, we felt like, you know what, we really do need some guidance on how people should interact on social media applications that are used by the school system. And so we went back to that document, and we turned it over to Tim and Doug and said, hey, scrub this and make sure that it's applicable for today, 2023, and how, you know, schools should utilize those apps and social media sites. And so they've done that. And so that's what's kind of reinvented this tool. So I'll be happy to seek some feedback and see if employees have any problems with it.
Oh. Okay. Any other questions? All right, proceeding. 3.5. Ms. Stein, you're on about the increased food service budget for 23.
Yeah, as we're working on a 24 budget, we're going to try to increase the FY23 budget as well. But due to a continued increase in operational costs and the increase in meals served, we are going to exceed the revenue budget for the food service fund this year by an estimated $935,000. So this request is just being brought to you guys to appropriate those funds for this year to make the total budget $3,125,805 for fiscal year 23.
Has our reimbursement, I guess the state understands inflation and wants to push any more money to us?
Yeah, well, the federal, the estimated budget lines that this will go through is the federal flow through is estimated to increase by about $500,000 for the meals served and things like that. So it is an increase in federal funding as well as the local funding, not local from the county, but local from meals served and paid for. So it's a good problem to have, I think.
Yeah, well, yeah, exactly.
So we'll bring this to vote next, your March meeting, yes.
Any other questions? Thank you. Okay, going on to 3.6. Request for reappropriation of 2022 fund balance. Ms. Shepherd.
Yeah, so you've heard me discuss this at some of our budget meetings about the amount of money our fund balance from last year, and I'm actually going to let Angie talk about it if she
Okay.
if she feels comfortable doing that. But you've heard me mention it a couple of times in the previous history.
So this is the time every year that this comes about. After our audit is complete, the auditors work with our staff and finance to figure out what part of the fund balance of the county is schools, and then how it's broken down, whether it's our operational funds that we're returning or special budget funds. And basically what this comes from as far as the special budget goes is any monies that are still anticipated based on expenditures already made need to be carried forward so that we can balance the revenue with the expenditures for that next fiscal year. So this year, the fund balance for the schools was $5,439,317. Of that, $1,653,720 was these special budgets. So really, based on the new way that the county wrote their resolution, we don't need their approval for the special budgets. Just wanted to bring it to your all's attention, and we'll bring it to theirs as well. The $220,666 was capital money. You've probably seen that number before because we actually carried forward that exact same amount from 21, and that is what is being used to pay for the lights at Mountain View softball field. So that project, I think, is almost complete, but we will be paying for it and using that money. We just need to appropriate that money to spend it this year. We don't have any other capital to carry forward because we're still using the lease revenue money, the $4.2 million that they took out in 21. So you won't see any capital carry forward for that because that's just reimbursable money for the county. The remaining money is $3,564,931. That we will be giving back to the county as legally required. And then we'll see what we can do with it from there.
You'll hear during the budget presentation here in a few minutes about what I would recommend to do with those funds.
So again, we'll, if you guys approve this at the next meeting, I will take it to the county. I think their second March meeting probably will be for information, and then they can vote for it and appropriate it then, at least the $220,000 in their April meeting.
Questions? All right, going to 3.7. Angie, you got to speak to the Starnes distribution for 23.
I sure do. All right, so the Donald and Mary Starnes Educational Trust changed their distribution funding from fiscal year to calendar year, which we still appreciate the funding, but it was much easier on the fiscal year because we could budget appropriately. However, the funding is doing well, and their distribution for calendar year 2023 is $168,770. This is in addition to what we got for the fiscal year 23 because it was given to us in July of this year. So I just am requesting the appropriation. I believe Jennifer and her staff are looking at different ways to, obviously we don't want to hold on to those funds. So there are some different ways that we can utilize that. A lot of it goes to staffing. However, with getting this additional money in this fiscal year, we may be getting some equipment or some things like that that, that qualify through the Starnes money.
Questions?
Did one of your new board members propose that? Because we did the same thing with the foundation.
So the way it happened, it's easier for the financial company to do it on a calendar year versus a fiscal year. That was the reasoning.
And it is. I get it.
It is for investment because we don't do a lot of that.
Absolutely, but
fiscal year we do for schools and that kind of thing.
Yeah.
Okay.
So we'll after we get through this initial year, we'll have a better idea of how to budget it, but this year we're just kind of getting an extra check.
Right, and as a reminder, this is all special ed related, the Starnes Trust.
Yes. And it is in our special budget.
And I think it provides money for dual enrollment as well. Yes.
Dual enrollment,
Yes.
okay.
Yes.
Good. Okay, thank you.
Okay, moving on, the chairperson is going to call a TV timeout for the tech people to get live stream up. Take a 5-minute break or less. Ms. Judge, is that fine?
It's like me. I don't know.
My kids.
I'm 52. I should not
be
groan
groaning
when I
this
stand up. When Kyle starts groaning, we'll know.
Right.
I just didn't that time.
It doesn't look like we have any speakers for public hearing.
Kinsley.
We ready?
That's why I said that.
All
But
right, I'd like to reconvene.
No, we did not go out of session.
Excuse me?
We just had to recess, we didn't go out of session.
We're back.
Timeout's over. All right. Proceeding, Ms. Hodges, about the insurance.
Tonight, we have our insurance consultants here with us from McGriff Insurance Services. They're going to provide a short presentation and then also provide an opportunity for questions. This is Renee Yates, and we have Scott Yancey joining us virtually.
Good evening. Can everybody hear me okay?
Yes.
Awesome. Well, first of all, my apologies for not being there in person. I promise I will do better next time, but you have Ms. Yates there representing our agency, McGriff Insurance. So thanks to her for making herself available to be there in person. And good evening to the school board and the chair and Ms. Shepherd. It is a pleasure to join you, albeit remotely. So I was asked just to provide kind of a high level of the health insurance, the benefits renewal for July, kind of where we are, and I think the best place to start would really be where we've been. So Renee, if I can get you to maybe hit the next slide.
I don't have my glasses on, just a second. Okay. Perfect. There we go. Okay, we're good now. Sorry.
Perfect. I'm assuming everybody can see the slide okay? Outstanding. So just to kind of reset where we've been, you know, for years and years, the schools were with the local choice program for their medical, dental, vision, and employee assistance. And as we may recall, a couple of years ago, late in 2020, the Valley Health System provided notice to Anthem of its intent to terminate its relationship with Anthem. And of course, Anthem is the network that's utilized by the local choice. So back in late 2020, Renee and I worked with Linda and her team in the schools there and moved the medical, dental, vision, and EAP to Aetna. We moved it to Aetna mid-contract year because historically, the health insurance at the schools has run from a July to June year. But because of that pending at the time termination of Valley Health, we moved to Aetna January 1 of 2021, secured an 18-month contract, and then we had our first renewal with Aetna last July. And just to remind us a little bit about that experience relative to that first renewal with Aetna, when the renewal was run last year, the loss ratio, which is a key metric in the renewal, was 110%. So unlike in school, over 100 is not good when we talk about loss ratios, right? That means for every dollar in premium the schools had sent to Aetna, Aetna paid $1.10 in claims. In addition, last year, another key metric is what we call trend in our world, which is really synonymous with medical and prescription inflation. So one of the reasons we have a health insurance issue in our country is that inflation on medical and pharmacy is much higher than general inflation. Last year, that inflationary or trend factor was a little over 11%. And the initial renewal we received last year from Aetna on the health insurance was in excess of 45%. Okay, that's what we call the formula number in our world. That's when Aetna plugs all those various metrics and numbers into their renewal formula calculation. It came out in excess of 45%. That lovely lady, Renee Yates, who I introduced a few minutes ago, she is very shrewd at negotiating with carriers. So she beat up Aetna quite a bit last year to get that 45 reduced to a little bit under 23%. That's on what we call like benefits. And then you may recall last time I was there with you all, we talked about a few benefit changes that we made. We also reduced the number of plans that were offered from 3 to 2, and that brought the final increase down last year to about 12.3%. Okay. We had started talking with some of the staff there, Linda and her team, late December, early January this year, about going out to bid for July. In particular, there was an interest in allowing Anthem to take a look at your coverages and providing a bid, a proposal for July. And then in mid-January, we got thrown this curveball. So you may be familiar with what's on this slide here. I simply pasted 3 paragraphs from an article that was in the Winchester Star in January 19th. And in short, what it's referencing is comments made by the CEO at Valley Health. They are again in a dispute with Anthem regarding $15 million, and what Valley Health indicates are unpaid reimbursements. There is a federal case that's been filed, and it's been continued into 2024. And the current Valley Health contract with Anthem is set to expire at the end of 2023. And as you can see from the quotes here in this article that we've included, the CEO of Valley Health is indicating a probability that Valley Health will discontinue participating with Anthem at the end of 2023. So we've taken a bit of a pause in putting out an RFP, given that we're not certain that if we were to receive a favorable response from Anthem, given the potential disruption that would occur at the end of 2023, if we would be able to move the coverage away from Aetna. Which kind of leads to the next slide, Renee, perfect. So here's where we are as we gear up for a 2023 renewal, just relative to some of those Aetna metrics. The loss ratio has come down, still not great. If we look at the most recent 12 months of claims that we have, it's come down to 103% from the 110 we talked about last year. We have 2 individuals that have claims over 300,000, 8 individuals who have claims over 100,000 for the most recent 12 months. You see there, I indicate that's 19% of total claims, those 8 claimants with claims over 100,000. Not to get too nerdy, but actuarially, we'd expect the claims over 100,000 to be about 12 or 13% of total claims. So we're a little bit high there. But here's the good news. Who wants some good news? If I can see a show of hands in the room.
I think it's the entire room.
I kind of built up to that. So claims, what we call plan year to date. So we made some changes I talked about on that first slide, right? We made some benefit changes for July. Since the new plan year started July 1, we've received 4 months of what we call complete claims, July through October. And for those 4 months, the loss ratio has reduced to an 84% number, okay? So we're now getting about where Aetna would like to see your claims run, right? A mid-80s, 85%, 84% loss ratio. So that is good. Things have improved, but when Aetna does their formula renewal calculation, they're going to look at the prior 12 months. And again, that prior 12-month loss ratio is still 103. Now, again, what Renee and I do, and Renee's better than anybody, is we negotiate with them and we say, hey, let's focus on the most recent 4. They're the most credible. You know, we had this whole kind of back and forth discussion with Aetna relative to what the renewal should be. We still see trends above 11%. I can tell you carriers other than Aetna are using trends higher than 11.5. A lot of that, I think, is some post-COVID impacts and effects. But that's kind of where we are with Aetna. To date, we're still, the message to Aetna has been, we're still evaluating whether we're going to issue an RFP. And we've kind of given Aetna indication that it might behoove them to provide favorable numbers in terms of renewals to perhaps mitigate going out to an RFP. But that's really the discussions that are going on to date. And I just listed here the last bullet point, kind of why we are where we are, why we are where we've been last year and this year. We talked about this last time I had the pleasure of being with you in person. If you remember with the local choice, pharmacy data is not provided. We don't get your specific pharmacy claims from when you were with the local choice. We have your medical claims, not your pharmacy. And as I'm sure you're aware, pharmacy costs and pharmacy claims are a growing part of your total claim spend. So Aetna 2 years ago had to kind of roll the dice on what they thought your claims would be on the pharmacy side in projecting or developing your rates, and candidly, they underprojected what your pharmacy costs would be. I do believe too that the second item there is Anthem's contracts with hospitals and physicians provide lower reimbursements to the hospitals and physicians than Aetna's contracts bear out, which means Aetna's rates have to be a little bit more to compensate for that. Candidly, that's one of the reasons Valley Health is probably not too happy with it. I think we have had a sort of what we call in our world a spike in high-cost claimants, back up to that bullet point above, talking about your individuals that have claims over $100,000. And just to kind of, you know, when we talk about your prior renewals, your 2019 renewal, which was the last renewal with local choice, well, see, that was the last one. Yeah, that was a decrease, I believe. So we really, you went 2 or 3 years without any increase in cost when you moved to Aetna for 18 months mid-year. So that's kind of, wait, did someone have a question, Renee? I'm sorry.
I don't think so. I don't think so.
Okay. Yeah. So that's sort of the state of the union, if you will, right now relative to where we are with the health insurance for next year, the discussions with Aetna, and really the update with Anthem and Valley Health, and why that's concerning for us relative to going out to bid with an RFP for next year. Questions that we could answer?
What's the cost on doing an RFP?
Well, in terms of McGriff's cost, we're glad to do it anytime that the schools are interested in it, and we don't charge extra for putting out an RFP or conducting the analysis for that.
Okay, because I know, I was just looking, Valley Health also accepts Cigna, United Health, Humana. They have a whole.
Yeah. Well, Humana announced today they're exiting the group health insurance market, so Humana would be one to cross off the list. But certainly, you know, Cigna, United Healthcare, Aetna, you know, Optima has just recently negotiated a new contract with Valley Health. They're all certainly viable. I would tell you, when we went out to bid 2 years ago, because we went to all those carriers 2 years ago, Aetna was kind of the clear best option from a cost perspective 2 years ago. Not to say that would stay the same, but we certainly hit all those carriers, and they all responded to the RFP back 2 years ago.
A question for you. Can you give me, and I don't know if it falls under, you know, information that you cannot, I'm assuming that you handle other school districts as well, and how we fall in a loss ratio. I know we keep hearing that our loss ratio is high. Where are we compared to everybody else that you may serve?
No, I appreciate you asking that question. So the other school systems that Renee and I have worked with are self-funded on their medical. So I don't know if we want to let me just explain real briefly what that means. So when you're self-funded, you're using an Anthem or an Aetna just to process claims, and you're paying them an administrative fee to process claims, but you as the entity are funding those claims. So I don't think we're quite ready to go down that path yet with the schools, given the loss ratios are over 100%. We'll let an insurance company take the risk for the claims. But, you know, I would say what we're seeing right now generally is claims running higher than they've run in recent years. And that gets back to a comment I made a little earlier. I think a lot of that has to do with COVID. And as you may recall, during COVID, there were periods of times where hospitals and physicians' offices were not seeing folks unless it was an emergency or unless they had COVID. There was a lot of preventive care that wasn't provided or received. And so we're seeing higher acuities of cancers and illnesses now because they were sort of, they were not diagnosed early, or as early as they typically would be. So as I mentioned, when trends, inflationary factors on medical and prescription had gotten down to be around 8 or 9%, now the carriers are using 12%, 14% trend factors, which really is indicative of the fact that claims have been running across the board at a higher level than carriers had projected and predicted.
Okay. I'm not sure if I don't know if that answered my question or not, or maybe I just misunderstood. Rockingham, Clark, Warren, Frederick, if you deal with any of those, I'm not sure what other school districts, are their loss ratio as high, or are they all self-funded?
So Renee and I have worked with Rockingham and Harrisonburg. They're self-funded. So it's kind of an apples to oranges thing to say, we don't really, when you're self-funded, you really don't deal with a loss ratio per se. You deal with claims to projection. And I can tell you with one of those entities, claims for the current year are fairly higher than projected in the same ballpark that you're in.
Okay. Thank you.
Mm-hmm.
Other questions? So we should have a definite by a couple months before we approve the budget, I hope. Ms. Hodges?
Yes.
Or, yes.
Yes, sir. That question is, so from my perspective, if the decision is made that we're not going to pursue an RFP, I think Renee and I can have our negotiation sessions with Aetna, and in a matter of 2 or 3 weeks, have some final numbers to look at.
Any more questions? Okay, thank you.
Thank you all. I appreciate the opportunity to chat with you.
Okay, coming down to 4.2, Ms. Shepherd, the budget.
All right. So in front of you, you should have our budget book for fiscal year 2024. And the budget book is in 4 categories, 4 sections: executive, organizational, financial, and information. And I am just going to highlight a few things. These are yours
Please
to keep,
highlight a
to
few
take, to take with you and study at your leisure. So on page 15, and some of these things I've mentioned in the last 2 meetings, but want to just tell you where you can find them in this book. On page 15, you will see the budget development calendar for fiscal year 2024. And I just want to highlight 3 meetings in March. March the 9th at 7 p.m. is a regular school board meeting, but the school board will approve budget at that time. March the 16th is the Board of Supervisors work session on education, and that is at 1 o'clock. And then on March the 21st, the Board of Supervisors will establish tax rates for their advertisement. And then in April 18th, the Board of Supervisors will adopt their budget and their tax rates. At this time, the General Assembly concludes, I believe it's this Sunday. I have heard that they are still negotiating the budget piece of it. So I do not think we will have an idea by our March 9th meeting of what state funding we will receive. So, that is very much like last year, I think, when we went well into April before we knew what our state funding was going to be. So, that's, we will see. So then if you will turn the page, you will see our budget priorities. So that's page 16. And you will see Fund 1, Fund 2, Fund 3, Fund 5, and Fund 6. So Fund 1 is our operating. That's where salaries and insurance and those day-to-day expenses come from. Fund 2 is our special budget. You heard Ms. Stein talk about STARNS. That's that's where that money resides in our special budget. Fund 3 is capital projects. That's all of the work that we do to our facilities. Fund 5 is food service, and then Fund 6 is county technology services. And then if you will turn the page to page 18, you will see a summary of our positions here in Shenandoah County. And a few notes off to the side. I do want to iterate and reiterate and then reiterate is that the teachers, you'll see that we are reducing by 10 teachers, and that's based on our class size. But we are not doing a reduction in force. As people resign or retire, then we're looking at those positions to see if we need to fill them or not based on class size numbers. So we are not planning on doing any reduction in force or anything like that. So just want to make sure that our employees know that that's not how that's going to happen. And just stop me whenever you have a question, Mr. Housley.
Oh, it's not just me, my colleagues. Feel free to interject a question. Proceed.
Thank you. So we're going to move into the second section, organizational. And on page 25, you will notice a chart there that shows that Shenandoah County School Board is still the #1 employer here in Shenandoah County, and we have been the #1 employer for many, many years. So just wanted to point that out. On page, we're going to move into the financial section now. On page 37, you'll see our requests. So our total operating budget for fiscal year 23, so that would be school year 22-23, was $76.8 million, and the proposed for fiscal year 24 is $81.6 million.
Ms. Shepherd, that does include the county technology.
Okay. Yes. Thank you. And if you will turn the page, you will see that you'll see the charts that show the proposed state funding increase, the proposed local funding increase. State funding increase, we anticipate based on the tools that we have that we're going to get an additional almost $2.8 million from the state. And then we are asking for an additional $1.95 million from the county.
And the snafu at the state level about the funds that we anticipated didn't get it, that's going to be coming our way?
Yes.
In 2023?
Both the General Assembly, the House and the Senate, in their budget amendments have proposed that they're going to make that budget neutral for school divisions, so they will be sending that money our way. But I do want to remind you that for the operational, we are requesting an additional $1.95 million. But I want to remind you that $2.1 million drops off in debt for this fiscal year from the county will pay its last debt fee, service fee, here this year, and $2.1 million will drop off, and that was from the high school renovation. So just wanted to remind you of that. If you look at page 39, you will see that the state funds us about 54.4%, and then the county is at 39.3%. And you'll see federal and other and county CIP and technology, so on and so forth there. If you turn to page 41, you'll see that 75.2% of our budget is for instruction, as it should be.
So do you think that if, once that debt drops off, and maybe this is a question for Tim, that you'll be giving refunds back to the county since we won't have that debt?
Refunds?
Yeah, tax refunds, yeah. Since we're not paying, since we paid something off. Yeah, since we've paid something off, we'll probably see refund checks, right?
That didn't work out together.
Okay. You all heard that, right? Okay.
It's on camera. It's
I think he is one of 6. Last time I checked.
He is. I'll work on the other 5. I don't have a problem with that.
Well, I know who you can start on first.
On page 42. So last year we heard a little bit about categorical funding, and there, based on code, there are 9 categories, and the categories are instruction, attendance, administration, attendance and health, pupil transportation, so on and so forth. You can read them there. The school division would use 5 of these categories, and that would be the ones that are underlined. So instruction, administration, attendance and health, pupil transportation, operation and maintenance, and technology. So we do have a separate fund, which is the school food service and other non-instructional operations, which would be 6. So, so we have, if you turn the page to page 44, you will see that Ms. Stein and her team have allocated the budget such that we could do categorical funding if the Board of Supervisors would like to do that. So if you see instruction is $60,920,987.91. Angie usually rounds up.
It's the personnel services.
Yes. Administration, attendance, and health would be a little over $5 million. Pupil transportation would be $6.2 million, a little less than $6.2 million. Operation and maintenance would be a little over $6.8 million, and then technology services would be $2.146 million. So we have allocated the funds such that they could be funded by category if that is the pleasure of
I think the Board of Supervisors, especially one member, requested this, didn't he not?
Yes, so it's here, it's available for them, so. And then the food service, we'll get to that as we go through so you can see what that amount would be. I do want to, page 45, 89, almost 90% of our budget is salaries and benefits. It's people. And we know that the #1 impact on student learning is our teachers in our building, followed very closely by #2, the school administration. So, just know that salaries and benefits are 89.2% of our budget. So, it's people. So on page 46, you will see that our highlights of our budget initiatives associated with our goals, our strategic goals. So new career and technical education programs, $330,000. That's HVAC and OT, PT, assistant. So those 2 programs will cost an additional $330,000. Capital funding for urgent and necessary projects, that's 3.1. Recall what Ms. Stein said earlier, that we are returning $3.56 million to the county, and we would like to ask that $3.157 of that be returned for our CIP projects. So that's actually a net gain for the county in the amount of $380,000. Fuel increase of $150,000 this year. We need to get our kiddos to and from school every day. We have received a VDOE security equipment grant up to the amount of $250,000, but we have a local match to that, and that local match is usually about $62,500. And we haven't budgeted for that, but every year we've been receiving that security grant, so we need to budget for the local match because we want to receive those that security grant because it allows us to do security cameras, door locks, things like that in order to keep our students safe. The largest request that we have is the salary increase for all employees, which is a 7% plus step, and that's to the tune of about $4.7 million. We would like to re-benchmark our food service scales, but that is going to come out of food service funds. It does not hit our operating budget at all. And then if you turn the page, our allocation for health insurance increase and additional dependent coverage is about $1.7 million. Again, we won't have the final numbers on this for a couple of weeks to, a month. And our plan is to increase the employee plus one coverage from $300 to $500, and then the employee plus family from $400 to $600. So that's about $600,000, which is included in that 1.7 million. And if you'll look on page 48 at the bottom, that's what in the yellow, that's what our employees pay for health insurance. And the majority of our employees are on the Aetna 1000 with comprehensive dental. On page 49, you'll see the comparison that I shared, I believe, at the last meeting. And then you'll see a summary of the budget requests. So skipping forward, on page 52, you will see Fund 2, which is our special budgets, and you'll see a total there of $7.2 million. We anticipate this will decrease next year because most of our CARES funds will be gone by the end of. Ms. Proctor to my right says all of it will be gone by the end of this coming fiscal year. Capital projects, that's Fund 3 on page 53. And, that just talks about our capital projects. We've talked about $3.157 million. And you'll see on the subsequent pages, the information that's been presented over the last several meetings. If you look at page 60, you will see the food service fund and what the proposal is for next fiscal year, and that's $3.85 million, and that would be the categorical funding for that particular budget. If indeed the Board of Supervisors would like to fund us by category. So. Food service is self-funded, so the revenue they make is what they're able to expend. Fund 6 is technology services, and that is going up slightly, $1,359 for next fiscal year. Just a few more highlights. If you will turn to page 66, this is information that's been presented over the last several meetings. It just talks about our student demographics and our enrollment projections, so on and so forth. And if you turn to page 74, that's some new information that has not been presented in any previous budget presentation. It talks about on-time graduation. It talks about our dropout rate. There's some charts and graphs there. It talks about some student success from our graduates from last year. And then page 76 talks about our CTE program. Page 77 about college acceptance rates. And then page 78 is industry certification, dual enrollment, and national board certification of our teachers. So I'll let you kind of just look through that briefly. So on-time graduation rate, I just want to highlight, our on-time graduation rate is 97.7%, and we are just slightly behind Page County there. Our dropout rate is, we are lower than the state, and our dropout rate for last year was 2.1%. And we, again, are just right behind Page County. And then if you will turn to page 83, that starts the salary schedules. And the first one is the proposed teacher, and that's with a 7% increase, which the General Assembly, both the House and the Senate, are proposing that in their budget amendments. The governor on December the 15th or 16th proposed a 5% pay increase, but I think he is very supportive of the 7% based on information that I've received. And then you can scroll through the salary schedules and look to see. Unfortunately, I was hoping we would be able to look at some of the salary scales and that we weren't able to address last year. But due to a 7% increase in the cost that it's going to cost us to do that, we weren't able to look at individual scales like we were last year. I think we look at the parapros, the nurses, the bus drivers, the teachers, custodians. I may be leaving one out.
I know athletic directors are behind from what I've been able to look into on the scale, so that'll be something for us to look at moving forward as well.
So, and I've highlighted our page 76, our supplements. That's not what you were talking about, athletic directors, but supplements. We were hoping to actually look at our supplements this year as well. Unfortunately, you know, I don't think we're going to be able to. We were hoping we would be able to do something for band directors, and then which would be on page 97. And then if you look at page 99, we were hoping to be able to do something with our coaching supplements. But we did look kind of at a few of our coaches, and because they're, you know, if we get the proposed 7%, they are getting a pretty significant pay increase since we do it based on percentage. So, you know, some of our coaches will be getting $500 additional next year than they would get this year. Now, the amount of time that they put in with our student athletes, again, like I said, with our acting assistant principal and principal, it's pennies on the hour, but you know, it is acknowledgement that they are spending extra time with our students. So, and then on page 101, it actually talks about the taxes and of Shenandoah County, and then on page 103, there is a glossary of some of the key terms throughout here. And I should have added all of the terms that Mr. King had on his slide earlier, so it would be a lot larger document if we had all of those on there as well. So, but be happy to answer any questions. It's, you know, this is a nice book that you guys can, you know, kind of look through at your leisure, but be happy to answer any burning questions that you have on the budget. So there's nothing new here that wasn't proposed previously.
Thank you. I always appreciate this. Because, you know, I end up putting stuff out all over the place, and about an hour into it, I'm confused and just want to walk away from it. So this is very nice.
So this is a labor of love. I've got to thank Ms. Stein.
How many hours was put by your staff to put this together?
Thank you.
15, 20 minutes.
It was more than one, right?
Just over one.
She did it on a break. Just, you know.
And how many iced teas did you get from Arby's to go through? Oh, was that Arby's?
I've lost count.
Yeah.
It's been fun.
I do have a quick question. I did not realize, and I think I shot you an email, I had learned today that our field trips are funded by grants. Our teachers have to write grants to fund field trips. Am I correct in that?
I'm going to defer to, and I saw your email, but to Jennifer and Chad, who are the ones who could answer that question. So,
do we have a fund for that, or are we writing to? I mean, is it a grant funded? What?
So each school has money set aside in transportation for field trips.
Okay.
And then each school also has funds that they can, from our pot that they get, that they can put to the side also for field trips. So if they are writing grants, it's because they are taking it upon themselves. I know, like, for example, the Stanton
Frontier Culture Museum.
Frontier Culture Museum. They have, if you write a grant, they will give you free And so like that's sometimes what they'll do just to get free field trips.
And
But
an
they don't-
air-conditioned coach.
Yes, but they
not a school
don't,
bus.
because it's so far, because we're far enough away, but they don't have to do that.
Okay, so how does a teacher, if she wants to take a field trip, say to Natural Bridge or to the Frontier Museum or to the front, the zoo there at Natural Bridge, which I highly recommend, how do they go about getting those funds?
They just need to talk to their principal.
Interesting. Okay.
I mean, I can also say the PTOs in the past have also helped support some of those initiatives if we didn't feel like we could do it at the school level, but we've always been able to do it at the school level.
All right. I appreciate that.
And our students who went to summer school this year went on quite a few field trips,
Right.
and they were funded, by the division.
Right, so when I got this information from two different people, I'm like, really? I mean, we had a whole summer school that was nothing but field trips. I mean, it was fabulous. Field trips are important.
Experiential learning.
Correct. I'm glad, you probably could say that, I could not, so I appreciate that. But yeah, they're extremely important. So I was like, when I heard that we were having teachers take their planning period to write grants to get money, I was a little concerned. And I was like, maybe we need to address it, but I appreciate that. I'll have to take that information back and see where the disconnect is.
And that was the same answer I got when somebody asked me, if we've got this surplus, why do teachers have to pay for their own supplies? They don't. They need to talk to their principals, because sometimes the answer is that's duplicative, or the principals know what's needed in the school.
I think unfortunately sometimes our teachers assume the answer
Right.
is no,
That's
and they're not
it.
going to their principals. To give you an actual story that happened to me, and I don't know if you were on the PTO when it happened. I went to a PTO meeting, and they could ask the PTO for supplies, and they asked for a pencil sharpener. And I was like, what? Nobody told me. And so I was like, no, don't buy that. We can get that. So like nobody came and asked me. So
Right.
it's just, sometimes they just assume the answer is no.
Okay. Well, if we start seeing an uptick in requests, it's because I opened this up. So just be aware that that's where that's at. All right, fabulous.
And, one of the things with Cindy's thing is I may say, I need $1,000 for supplies in my classroom, and Jennifer may say she only needs $250. So the principal has to weigh that, based on what subject area and what it's being used for, so.
Okay, thank you.
Any more questions? Okay, I adjourn this at 7:35. Okay, Ms. Jett.